Ladies and gentlemen, it is our duty and obligation and very great honor to make the following announcement and decree. On this day, the 21st day of September 2020, it is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default, that there has never been any such thing as law, but only the presumption of law, where a presumption is nothing of material substance and any presumption can be dismissed by a formal challenge. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default, that Parliament does not reign supreme and that any notion of government has no legitimacy without the material evidence that the governed have given the consent, and that there cannot be any government for the one cannot exist in isolation without the other. Also that any action taken by way of act or statute of Parliament is and always has been a criminal offence of fraud and malfeasance in the office at the very least. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default, that the office of the judiciary is nothing more than a sub-office of a commercial body, and the status and standing of any judge or magistrate currently on this land has no greater status or standing or authority than the manageress of McDonald's. Also, it is formally recognized on and for the record that the state is legal embodiment by an act of registration which is of no material substance and therefore fraud by default, and that the interests of the state are the interests of the state alone, to the detriment of anybody and anything else, including its own offices of the state. That the actions of the state are now recognized as an unconscionable and criminal fraternity capable of heinous crimes without measure. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default, that any and all executable orders and documents must carry an affixed common seal which denotes point of origin, and that any and all excitable orders and documents must be signed by human hand and in wet ink by a named authoritative living being who takes full responsibility for the content of that formal excitable order or document. Any deviation from this standing process where there is no affixed common seal or signature in wet ink by a living hand with authority to do so, will be recognized in perpetuity as a criminal offense. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default, that all imposed taxation and duty is and always has been not only a criminal offense but is also detrimental to all the people of this planet. Page 1 of 2. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default, that there is no such thing as money or commerce. Nobody gets paid or has been paid. Nobody has the capability to pay anybody or for anything or item without money. All commercial instruments are nothing more than pieces of paper with marks on them. That their value is only confidence and belief where confidence and belief is recognized as being of no material substance. The continued use of these commercial instruments is for the feeble of mind who insist on living in a make-believe world of their own making. Capitalism will forever be recognized and in perpetuity as the exploitation of another for personal gain. This has always been an unconscionable and detrimental activity to the human race since Babylonian times. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default. There is no greater sanctuary than the human home, be this home a castle or a wood hut or a blanket on the ground. From this day forward, as of the 21st day of September 2020, let it be known that any transgression of this sanctuary other than by invitation, that any transgression of this sanctuary is a recognized act of war and aggression. We have the right by the very fact that we live to protect our life and the life of our loved ones. Any transgression of this sanctuary can be met with equal or great force with impunity. This is the long-standing law and traditions of this land. So say we all. It is now confirmed formally, on and for the record as of this day, the 21st day of September 2020, agreed by the state and the Crown by way of unrebutted affidavit and statement of fact, and that there is a lasting tacit and binding agreement through acquiescence and royal assent by default. That the practice of election by way of secret ballot is and always has been an abomination and deception with no credibility or redeeming qualities. By the very fact that this is a secret ballot by any means of notarization or recording renders the outcome obsolete by definition that is a secret ballot. By the very fact that there is no recognized unelective or reverse process, and by the very fact that there is no such word to this effect in the recognized dictionaries. Then this elective process by way of secret ballot is and always has been void ab initio. Have a nice day. On and for the record. Bring out the town crier and let the bell ring. Let it be known across this planet, that from this day, the 21st day of September 2020, that the satanic Roman Empire is no more. Let it be by decreed that this is the day and will always be the day in perpetuity when the days of austerity and tyranny end for all time to come. Let this day go down in history across this planet as a day of celebration for all time. So say we all. Let the celebrations begin. So say we all. Page 2 of 2. Affidavit of Truth and Statement of Fact. 1. I, Anton of the House of Carpena, being the undersigned, do solemnly swear, declare and depose. 2. That I am competent to state the matters herein, and do take oath and swear that the matters herein are true, certain and correct as contained within this Anton of the House of Carpena Affidavit of Truth and Fact. 3. I am herein stating the truth, the whole truth and nothing but the truth, and these truths stand as fact until another can provide the material and physical evidence to the contrary. 4. That I fully and completely understand, before any charges can be brought, it must be firstly proved by presenting the material evidence to support the facts that the charges are valid and have substance that can be shown to have material physical substance as a foundation in fact. 5. From Exhibit A. Formal challenge to the 12 presumptions of law. A presumption is something that is presumed to be true, and as a presumption then there is only a need for a formal challenge to that presumption to dismiss that presumption until the physical and material evidence can be presented to support that presumption. 6. From Exhibit B. Case Authority WIO 5257 F. David Ward v. Warrington Borough Council, 30th day of May 2013. Which is a case at court tribunal undertaken by recognized due process. It is clear in the case that David Ward did not challenge the PCN or the Traffic Management Act 2004 Section 82. But what was challenged was the presumption of the consent of the governed. What is a mandatory requirement before the acts and statutes can be legally acted upon is that the consent of the governed has some validity and that it can be presented as material fact before any charges can be brought. It is clear from this case authority undertaken by due process that 1. It is illegal to act upon any of the acts or statutes without the consent of the governed where the governed have actually given the consent, and that consent is presentable as material physical evidence of the fact that the governed have given the consent. 2. Where the acts and statutes are acted upon, then this is illegal and a criminal action by the state. 3. The criminal action is malfeasance in a public office and fraud. 4. Where there is no consent of the governed on and for the public record, then there is not governed, and where there is no governed, then there is no government. The one cannot exist without the other. 5. As this criminal activity is observed to be standard practice and has been for nearly 800 years, then this is clear observable evidence to the fact that law is a presumption and there is no such thing as law. See Exhibit at the 12 presumptions of law. From Exhibit C. The material evidence of the facts. It has been confirmed by the RT. Hon. Lord Chief Justice Sir Jack Beatson FBA, on and for the record that sad face 1, whilst there is no material and physical evidence to the fact that the governed have given the consent, then the office of the judiciary has no greater authority than the local manager S of McDonald's. As the office of the judiciary is a sub-office of a legal embodiment by an act of registration, where this act of registration creates nothing of physical material substance and is also fraud by default. Any objection to this observation of fact should be taken up with the RT. Hon. Lord Chief Justice Sir Jack Beatson FBA, where the RT. Hon. Lord Chief Justice Sir Jack Beatson FBA would then have to present the material and physical evidence that the governed have given the consent. as the office of the judiciary is nothing more than a private commercial and fraudulent enterprise built upon fraud and criminal intent. This is by no stretch of the imagination a valid government by the people for the people, as it is by default a private company providing a judicial service for profit and gain, but where? Page 1 of 2. There is also and always a conflict of interests where there is a conflict of interests between the needs of the people and the state company policy, which has no obligation to the people or even the needs and well-being company staff. This has been confirmed by Chandran Kakathas of the London School of Economics and State Office titled The Department of Government. See Exhibit C, the material evidence of the facts. 7. From Exhibit D. It is quite clear that there is due process for the execution of legal and commercial documents. Where these processes are not followed, then the very presence of a document which does not comply with these processes, then the document itself is physical and material evidence of malfeasance in a public office and fraud. 8. From Exhibit E. It is very clear that all instances of taxation and duty, VAT is not only not necessary but only serves to deplete and subtract from the population's prosperity. Not only this, but as we have shown, it is also illegal and criminal to do so without the agreement or the consent of the governed. It is unconscionable and a recognized act of terrorism. The exhibit speaks for itself. 9. From Exhibit F. The facts are the facts. There is no money. The facts are the facts. A great number of people live their lives in a world of make-believe. Let us consider this. 2 barristers or lawyers will enter into a courtroom and one of them will lose. For some reason which is beyond our comprehension, it is a professionally accepted practice to have a 50% failure rate. In a world of reality, there is some people who service the planes at the local airport between flights. If these people had a 50% failure rate, then 50% of the planes would fall out of the sky. That is a fact. There is no money, just the illusion of money. There is legal tender and fiscal currency and commercial instruments and promissory bank notes, but there is no money. It is quite clear that a lot of people live in a world of make-believe and Alice in Wonderland, La La Land. There is no money. It is not possible to pay for anything without money. You never paid for anything and you never got paid. That is a fact. 10. There is no valid, legal or lawful government on this land. See Exhibit H, the hypocrisy of the secret ballet elective process. 11. From Exhibit G. My rights end where your rights begin. Your rights end where my rights begin. Rights are not granted by government or the Crown, and they cannot be taken away or violated by government or the Crown. The judge does not have the right to trespass on my property, so the judge cannot give a bailiff or a civil enforcement officer or a policeman the right by means of a warrant or an order, because the judge, who is a company servant by default, does not have that authority unless I agree. A public servant is a servant by default with the status of servant, and a servant has no authority above the one who grants that authority. Until the judge can present the agreement or the consent of the governed, then the judge has no authority to grant a warrant or a court order. Exhibit Case Authority WIO 5257F. David Ward v. Warrington Borough Council. 30th day of May 2013. Also Exhibit C, the material evidence of the facts. These are the facts. The material evidence of these facts has been provided. 12. This affidavit of truth and statement of fact stands on and for the record as fact until some other can present the material physical evidence to the contrary, which is valid. Without ill will or vexation. For and on behalf of the principal legal embodiment by the title of Mr. Anton Carpena. For and on behalf of the Attorney General of the House of Carpena. For and on behalf of Anton of the House of Carpena. All rights reserved. Page 2 of 2. Exhibit A. Formal challenge to the 12 presumptions of law. 19th day of January 2015. Page 1 of 6. Formal challenge to the 12 presumptions of law. Definition of presumption. 1. An idea that is taken to be true on the basis of probability, as a presumption, is a presumption on which must be agreed by the parties to be true. Then an equally. If one party challenges the presumption to be true on the basis of probability, then this is all that is recognized to be required to remove the presumption is a formal challenge to that presumption. The presumption then has no standing or merit in fact. A probability. 1. The extent to which something is probable, the likelihood of something happening or being the case. By definition then this is not substantive as it is only a probability of what may be and therefore has no substance in material fact. A state court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if presumptions presented by the private bar guild are not rebutted they become fact and are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds which if unchallenged stand true being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor, beneficiary, agent and agency, incompetence, and guilt. The presumption of public record is that any matter brought before a state court is a matter for the public record when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be on the public record, the matter remains a private bar guild matter completely under private bar guild rules. We, the undersigned formally challenge the presumption of public record as it is by definition a presumption by definition and has no standing or merit in presentable or material fact. Page 2 of 6. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn secret absolute oath to the guild then act as public agents of the government, or public officials by making additional oaths of public office that openly and deliberately contradict the private, superior, oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. We, the undersigned formally challenge the presumption of public service as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. The presumption of public oath is that all members of the private bar guild acting in the capacity of public officials, who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to the guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. We, the undersigned formally challenge the presumption of public oath as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. The presumption of immunity is that key members of the private bar guild in the capacity of public officials, acting as judges, prosecutors and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability. Unless openly challenged and their oath demanded, the presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors and magistrates are immune from any personal accountability for their actions. We, the undersigned formally challenge the presumption of immunity as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. The presumption of summons is that by custom a summons unrebutted stands and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons. Unless the summons is rejected and returned, with a copy of the rejection filed prior to choosing to visit or attend, jurisdiction and position as the accused and the existence of guilt, stands. Page 3 of 6. We, the undersigned formally challenge the presumption of summons as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. The presumption of custody is that by custom a summons or warrant for arrest unrebutted stands and therefore one who attends court is presumed to be a thing and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood soul-possessing beings. Unless this presumption is openly challenged by rejection of summons and or at court, the presumption stands you are a thing and property and therefore lawfully able to be kept in custody by custodians. We, the undersigned formally challenge the presumption of custody as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. The presumption of court of guardians is the presumption that as you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P, you are a pauper and therefore under the guardian powers of the government and its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter, trust before the court, the presumption stands and you are by default a pauper, and lunatic and therefore must obey the rules of the Clerk of Guardians Clerk of Magistrates Court. We, the undersigned formally challenge the presumption of guardians as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. VIII, the presumption of Court of Trustees is that members of the private bar guild presume you accept the office of trustee as a public servant, and government employee, just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged to state you are merely visiting by invitation, to clear up the matter and you are not a government employee or public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you appeared. We, the undersigned formally challenge the presumption of trustees as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. X. The presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoints the judge, magistrate in the capacity of executor while. Page 4 of 6. The prosecutor acts in the capacity of beneficiary of the trust for the current matter. If the accusers seek to assert their right as executor and beneficiary over the body, mind and soul, they are acting as an executor de sun tort or a false executor, challenging the rightful judge as executor. Therefore, the judge, magistrate assumes the role of true executor and has the right to have you arrested, detained, fined or forced into a psychiatric evaluation. Unless this presumption is openly challenged to demonstrate you are both the true general guardian and general executor of the matter, trust before the court, questioning and challenging whether the judge or magistrate is seeking to act as executor de sun tort, the presumption stands and you are by default the trustee, therefore must obey the rules of the executor, judge, magistrate, or you are an executor de sun tort and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriffs to assert the false claim against you. We, the undersigned formally challenge the presumption of government acting in two roles as executor and beneficiary as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. X. The presumption of agent and agency is the presumption that under contract law you have expressed and granted authority to the judge and magistrate through the statement of such words as recognize, understand, or comprehend, and therefore agree to be bound to a contract. Therefore, unless all presumptions of agent appointment are rebutted through the use of such formal rejections as, I do not recognize you, to remove all implied or expressed appointment of the judge, prosecutor or clerk as agents, the presumption stands and you agree to be contractually bound to perform at the direction of the judge or magistrate. We, the undersigned formally challenge the presumption of agent and agency as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. She, the presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge, magistrate as executor has the right to have you arrested, detained, fined or forced into a psychiatric evaluation. Unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions, then it stands by the page 5 of 6. Time of pleading that you are incompetent, then the judge or magistrate can do what they need to keep you obedient. We, the undersigned formally challenge the presumption of incompetence as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. She, the presumption of guilt is the presumption that as it is presumed to be a private business meeting of the bar guild, you are guilty whether you plead guilty, do not plead or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record or call a demurrer, then the presumption is you are guilty and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. We, the undersigned formally challenge the presumption of guilt as it is by definition a presumption, by definition and has no standing or merit in presentable or material fact. We formally challenge all presumptions of law and as we have formally challenged all the 12 presumptions of law, then the presumption of law formally has no substance in material fact. As a scholar of law and recognized RBA. Recognized by achievement, paralegal by the demonstrated knowledge at court tribunal. See enclosed case authority Exhibit B. David Ward and Warrington Borough Council 30th day of May 2013. Case No. WIO 5257F. We will recognize the rule of law, when and only when there is the material evidence of that assumed rule of law has some material evidence of substance in presentable material fact. Until then, the search for the rule of law that has some credibility in material fact continues. It is done without ill will or vexation. For and on behalf of the principal legal embodiment by the title of Mr. Anton Carpena. For and on behalf of the Attorney General of the House of Carpena. For and on behalf of Anton of the House of Carpena. All rights reserved. Page 6 of 6. Exhibit B. Case Authority. Case No. YO 5257F. David Ward and Warrington Borough Council. Date, 30th day of May 2013. Page 1 of 14, page 4 of 14, page 1 of 16. Page 2 of 16. Page 3 of 16. Page 4 of 16. Page 5 of 16. Page 6 of 16. Page 7 of 16. Page 8 of 16.